tribal tribes. He has been actively involved in formulation of social and public policy, program management, and program implementation for inclusive and sustainable growth. Sir, I hand over to you from here on. We have two participants who will be in the panel who will join us online, Shomona Khanna and Mr. Kundal Kumar. So from here over on. Thank you, sir.
Thank you, Shubha. It was a wonderful session, and the overall objective of this entire 2 days national consultation is part of the overall development of the tribal communities. Of course, we know what is the meaning of the tribal development. Tribal development, whether taking them into mainstream and bringing them to urban areas and providing them amenity. No, not at all. My thesis is to tribal development, a comparative analysis of tribal development, that to primitive tribal groups. What the tribal population, they are very happy in their areas, but unfortunately, as outsiders, we think that development in the sense what is living in the urban areas with posh bungalows, with all cars and having higher qualifications, working in the industry. That is not the development. And we can understand development in the sense happiness. Happiness in the sense wherever they are there, they should live happily, live with the community, support the entire community and also get the support psychologically, well. Overall, this development, of course, we have a development, human development. If we consider human development indicators, there are several aspects that may be related to health, related to education, related to infrastructure, providing basic communities like housing, drinking water, sanitation. There are many human development addressing the infant mortality, the health indicators like infant mortality rate, malnutrition. Various aspects are involved. So, of course, in these sessions, we have several dignitaries and, of course, the professionals who have worked with over the decades. In fact, we have Dr. S.B. Roy, founder, chairman of IIT, Professor Sri Bhagwan Rai, has done his MS in anthropology from the University of Calcutta, and a PhD on the biosocial change among the Caraïbes and Andaman Island, fellow of Society of Applied Anthropology, USA. After serving for nearly 20 years at the Anthropological Survey of India, he had served as a professor at Indian Institute of Technology, Kharagpur. He had been at East-West Center, the University of Hawaii, USA, for the study of society, forestry, and developed himself as a trained ecological anthropologist, and is the founder chairman of the Indian Institute of Biosocial Research and Development, established in the year 1985. He has also served as a visiting professor at different international universities such as at the IDPM, University of Manchester, the University of Wales, University of Helsinki, GM University, Indonesia, Kunming, and also China. Of course, really, sir is working with one of the project of Niti Aayog, that is TNT, semi-nomadic tribes, where we are studying the communities which are left out of the benefits. They are they are not in the SC, ST, OBC list, but they are living the like nomadic life and also demodified life. So they is part of that study also. I really thank you, sir, for your here with us. And of course, we have Shomona Khanna online. She has joined virtually. In fact, Shomona Khanna is a lawyer that is practicing in the Supreme Court of India and Delhi High Court, and has been associated with numerous civil and domestic rights issues since 1991, both as a lawyer and as a writer. She handled several cases in the courts, including on rights of manual scavengers, protection of women from sexual harassment at the workplace, and indigenous people rights. Between 2012 and 17, she was a legal advisor to the Ministry of Tribal Affairs, Government of India, after which she established the Legal Resource Center, a collective of lawyers and legal professionals engaged in demystification of the law for indigenous and Adivasi communities through legal workshops, training materials, and action research. I warmly welcome her also for this detailed deliberations and tribal development. And also we have Dr. Kundan Kumar, PhD. He is also on virtual mode. Kundan Kumar is a land and forest tenure expert with extensive experience on tenure issues in India at the global level also. He has led a number of global studies on the importance of collective rights of indigenous peoples and local communities for biodiversity conservation and climate change. In India, he has worked extensively on the issues of land tenure and environmental issues and has special interest in Forest Rights Act. He has taught at the University of Toronto and worked with international non-profit sector on land and forest tenure. Currently, he supports the Indigenous Peoples Unit in Food and Agriculture Organizations, known as the Indigenous People Resource and Climate Change Expert. Once again, I warmly welcome Dr. Kundan Kumar for this detailed deliberations. And also we have that Panchi Doctrine, she's from Center for Policy Research. Panchi Doctrine is a researcher, educator, and communicator of environmental law and policy. Other areas cover the field of environment, forest, and biodiversity regulation and governance in India. Our policy research and practice explores the links and gaps between law, development, sustainability, and environmental justice. Panchi has authored several reports, research papers, and popular articles as part of her work. She co-authored the course book Development of Environmental Laws in India and co-edited Business Interest and the Environmental Crisis. Panchi teaches environmental law and development courses at government training institutes and universities. We warmly welcome them for this discussions. With this context, in fact, we want to discuss on various aspects of tribal development, how we can proceed, and we have a question and answer session also. And also, we need valuable inputs from the practitioners, civil society organizations, executives from the state, and also there are many officials joined from the Ministry of Tribal Affairs also. In the backdrop of the audience. Yes, sir. So, I'll start with Dr. S.B. Rai. So,
Namaskar. I understand some of the participants are from village and other community. So, from time to time, I'll be speaking 1 or 2 sentences in Hindi, if you all can allow me. Okay. At this outset, I express my gratitude to Odisha, Scheduled Caste, Scheduled Tribe, Tribal Research Institute, Ministry of Tribal Affairs, and UNDP as the organizer. My gratitude to the organizer, the magnificent way it has been organized, so impressive, all over. Couldn't resist to participate and acknowledge. I'm also grateful to the officers over here who have been coordinating from time to time, contacting us in organizing a meaningful way. So my gratitude to all of you. Thanks, Mundi. After a long time, we met, discussed, and hope it will be all right. Sabko hamari shubhkamnaएं, my friends over here. What I wanted to share a few things. Tenure, security, and tribal development. That means if land is there for use, that is another purpose. किसी जमीन का या संपत्ति का व्यवहार करना और बात है. जंगल में हम हैं, are using it, but उस पर अधिकार नहीं है. So access and use is one aspect, control over other. So whenever there is a tenure, whenever people are allowed to control, that means the way they want to use it, what to do, what not to do. That tenure has got different kinds of that. And tenure security and tribal development, when we discuss of that, टेरिटोरियल सिक्योरिटी से एफआरए से ट्राइबल डेवलपमेंट हो रहा है या ट्राइबल डेवलपमेंट नहीं हो रहा है। तो कैसे कहेंगे डेवलपमेंट हो रहा है? कुछ मेजरमेंट होना चाहिए ना, या नहीं हो रहा है या हो रहा है। तो पहली बात है कि ट्राइबल डेवलपमेंट हो रहा है कि नहीं हो रहा है, वन शुड बी वेरी क्लियर उसका मापदंड क्या है, और वो मापदंड हम अपने से, इफ वी कैन फिक्स अप द मेजरमेंट criteria, whether it is scientific, whether this has been accepted by all, or it is my own. So, आप सब जानते हैं that Human Development Index (HDI) यह पूरे विश्व में माना जाता है ह्यूमन डेवलपमेंट, मानव विकास का या ट्राइबल डेवलपमेंट का एक मापदंड। Human Development Index is one of the criteria. And now with this सस्टेनेबल डेवलपमेंट गोल्स, यानी सस्टेनेबल डेवलपमेंट गोल की तरफ हम बढ़ रहे हैं। ह्यूमन डेवलपमेंट इंडेक्स जैसा होना चाहिए वैसा हो रहा है, तब तो ट्राइबल डेवलपमेंट हुआ, नहीं तो बहस की बात हो सकती है, अदरवाइज इट विल बी मैटर ऑफ डिस्कशन। तो पहली बात यह है कि एफआरए से ह्यूमन डेवलपमेंट हो रहा है या नहीं हो रहा है। एफआरए इज ए मीन्स, एफआरए एक ऊपर चढ़ने का रास्ता है, एफआरए मंजिल नहीं है, एफआरए इज नॉट द गोल, एफआरए इज वन ऑफ द मीन्स। तो दिस हैज टू बी वेरी क्लियर, पहले ही हम लोग मान लें एफआरए एक माध्यम है। नाउ क्या मेजरमेंट होगा? ऐसा मेजरमेंट कि गांव वालों को भी समझ में आए, हमें भी समझ आए। अगर कोई डॉक्टर होते हैं तो लोग को बताते हैं कि आप देख लीजिएगा टेम्परेचर कितना हो रहा है कि नहीं, आंखें कैसी हैं। तो दो चार मुद्दे, सिंपल क्राइटेरिया which tribal can also understand, expert can also understand, and the policy maker can understand. That simple criteria has to be there. So for that, health, education, and resource, these three are there. So my first point is that although health, education, and resource is there, but this is summation of HDI. अगर आप सिर्फ बोलेंगे आदिवासी का हेल्थ बहुत अच्छा हुआ है तो ह्यूमन डेवलपमेंट नहीं माना जाएगा। आप कहेंगे कि शिक्षा अच्छी हुई है, वो नहीं माना जाएगा। ये तीनों का समेशन। तो इसीलिए हेल्थ, एजुकेशन के जो सेक्टर हैं वो अगर एक साथ काम नहीं करेंगे तो लोग अलग अलग काम करके चले जाएंगे, लेकिन HDI नहीं होगा। आप जानते हैं अभी रिपोर्ट किया है, you all know the HDI of India, नीति आयोग has been regularly posting, and SDG, you are also doing that. आप जानते हैं हमारा विश्व में HDI और SDG क्या बहुत आगे है? क्या निगमन से नीति आयोग जी? नहीं ना, हम लोग पीछे हुए हैं। So let's understand that. और आदिवासी का HDI और भी पीछे है, तो गंभीर बात है। आपने खाना दिया, फॉरेस्ट राइट दिया, लेकिन वो खा नहीं पाते, तो खाना ही नहीं। So providing food is one aspect, whether they are taking it properly or not, then only there will be issue of malnutrition. Availability of food is not guarantee of malnutrition. तो ये सारे इसीलिए कन्वर्जेंस की बात होती है। नाउ एक बात मैं आपको बता दूं, हम लोग ह्यूमन डेवलपमेंट और ट्राइबल डेवलपमेंट की बात करें, but discuss the ट्राइबल डेवलपमेंट। कल मिश्रा जी हमारे साथ थे। ट्राइबल डेवलपमेंट के लिए हम कोशिश कर रहे हैं, अच्छी बात है, ये नहीं हम उनके ऊपर उपकार कर रहे हैं। We are not, it's not a dole, it's not a mercy. ट्राइबल डेवलपमेंट में जो उपकार हम उनका कर रहे हैं, I repeat इस बात को, ट्राइबल डेवलपमेंट why it is important, not for the development of tribal alone. I repeat, it's not for the development of tribal alone. It is the development of the landscape, the development of forest ecosystem. My dear friends, you know हमारे हिंदुस्तान में, पांडे जी, हमारे हिंदुस्तान में nearly 25% फॉरेस्ट रिसोर्स है, ठीक है ना? और आदिवासी कितने परसेंट है? अब बता रहे थे ना 8.6, 9 से कम, यानी 9 से कम लोग, 9% से कम लोग, उनके पास प्राकृतिक संपदा का संरक्षण, आपके पास 24% फॉरेस्ट का, और फॉरेस्ट ट्रीज की बायोडाइवर्सिटी ली जाए तो नियरली 50% biodiversity is with the tribal. Imagine if that biodiversity is disturbed, you are disturbed. तो मैं ये बताना चाहूंगा ओटा साहब कि एफआरए आदिवासी के लिए नहीं, ओटा साहब के लिए. Yes, it's for me, it's for all, and that is why Niti Aayog is working rigorously on the SDG monitoring. और वो SDG के लिए क्या होता है, ये वर्ल्ड का यूनाइटेड नेशन ने कहा है कि इस सेंचुरी का, इस डिकेड का सबसे ज्यादा प्रॉब्लम है क्लाइमेट चेंज, और दिस इज ड्यू टू लॉस ऑफ बायोडाइवर्सिटी. यानी बायोडाइवर्सिटी, क्लाइमेट चेंज, आई रिपीट, बायोडाइवर्सिटी कंजर्वेशन, क्लाइमेट चेंज is with tribal development. Is a link. You cannot think about it. Next. Now, why I wanted to share here quickly. This is like yeah. Why I will quickly share here. So, mudda kya hai? I just in 5 minutes wanted to establish that tribal development is there. So, for that we have to have health education तीनों का और सस्टेनेबल डेवलपमेंट गोल. अगर एसडीजी करेंगे, व्हाई आई वांटेड टू टेल यू, एसडीजी 1 इज जीरो पॉवर्टी, एसडीजी 2 अगर नहीं होना चाहिए, एसडीजी 3 क्या जी, एजुकेशन, 4 हेल्थ, 5 विमेन एम्पावरमेंट, 6 क्वालिटी ऑफ वाटर. पहले यही की बात करें. अगर पॉवर्टी रहेगी तो हेल्थ ठीक नहीं होगा, नॉलेज नहीं होगा तो एम्पावरमेंट नहीं होगा. और एसडीजी 6 पानी, क्वालिटी ऑफ वाटर, अगर एसडीजी ठीक नहीं रहेगा तो हेल्थ भी नहीं होगा और खाना भी नहीं होगा. एसडीजी 7 व्हाट इज अ क्वालिटी ऑफ एनर्जी, प्योर एनर्जी. और इसके अलावा और 3-4, एसडीजी 13 जो है क्लाइमेट रेजिलिएंट के लिए, एसडीजी 14 जो है अंडर वाटर बायोडाइवर्सिटी, 15 जो जमीन के ऊपर बायोडाइवर्सिटी है. मैं ये कहना चाहूंगा कि इसमें से कोई भी एक अभाव होगा तो ट्राइबल डेवलपमेंट नहीं हो सकता है. इसीलिए कन्वर्जेंस की आवश्यकता है. आई वांट टू रिपीट द लॉजिक व्हाई कन्वर्जेंस की बात करते हैं. इसलिए नहीं कि अच्छा लगता है, अगर इसमें से एक भी कम होगा तो ट्राइबल डेवलपमेंट नहीं होगा. और हर एक आदमी क्या करेंगे, अपनी अपनी बात करेंगे. तो ये एक बात थी. अब इसका क्या होना चाहिए केंद्र में कि हम लोगों को सोच को कंजर्व करना है. नेक्स्ट. तो इसलिए आपने दिया, देने के बावजूद भी अगर कंजर्वेशन नहीं हो रहा है तो वो नहीं हो पाएगा. तो ये ग्राम सभा पर पहुंचना पड़ेगा. और एक छोटी छोटी बात, मैं कन्वर्जन की लॉजिक दे रहा हूं. क्यों कन्वर्जन आवश्यकता है? एक तो कहा कि एसडीजी 1 से लेकर सभी करेंगे तभी डेवलपमेंट होगा, एक अकेले करेंगे तो नहीं होगा. दूसरी बात देखिए, फॉरेस्ट एक्ट में और बायोडाइवर्सिटी एक्ट, एफआरए एक्ट, ये राजू जी जानते हैं एक दूसरे के पूरक हैं. दीज आर कॉम्प्लीमेंट्री. When we are going to implement Forest Rights Act, उसमें कहा गया है सस्टेनेबल यूज. एक छोटा सा वर्ड है फॉरेस्ट राइट एक्ट में. बैठे अपने एक्ट की बात हो रही है, उसमें एक छोटा सा शब्द है सस्टेनेबल यूज. पांडे जी आप कहते हैं. फिर कहा गया है उसी एक्ट में, पता नहीं जो लोग एफआरए कर रहे हैं उनको याद होगा, एक छोटा सा क्लॉज दिया गया है, रेफर एज इन बायोडाइवर्सिटी. अब बताइए, गांव वालों का पट्टा दो, अब वो फंस गया. तो अगर हम इसको नहीं समझेंगे कि सस्टेनेबल यूज क्या होता है, तब तो एफआरए गया है ना, फंस जाएंगे. और फिर बोलेगा कौन से बात नहीं मानता है, और उसके बाद उसके साथ ये लगा हुआ है, तो सस्टेनेबिलिटी कैसे मालूम पड़ेगा जी? यहाँ पर जो भी इकोलॉजिस्ट बैठे हैं, मैडम कोर्ट से आई है, नीति आयोग के लिए है, रिसर्चर है, हमारे एंथ्रोपोलॉजिस्ट है, कोई बता दे कि ये सस्टेनेबल यूज गांव वालों को बताया जाएगा तो वो समझेंगे सस्टेनेबल यूज हो रहा है। कोई बता दे, आई रिक्वेस्ट, आई सबमिट। तो ऊपर ऊपर बात करने से नहीं होगा। We have to understand the criteria of sustainable, जो गांव वाला भी समझे, फॉरेस्ट गार्ड भी समझे और ग्राम सभा भी समझे। तो अब हम आ गए हैं वे फॉरवर्ड। हमने तो इतना कह दिया, ये समस्या है, ये समस्या, ये समस्या, इतनी समस्या का लिस्ट होता है, ये है, ये है, ये है, बट व्हाट इज द सॉल्यूशन? व्हाट इज द वे फॉरवर्ड? The first way forward, I'm grateful to Osa. He had asked us to work on this policy. And he is such a polite, humble, click, acha outcome. And we have been working on that. We are grateful for this opportunity. I and Raktiba Sweta knows about it, how we're working on that. The first thing is that we have to reposition our institution. अगर आप फुटबॉल खेल रहे हैं, ठीक है ना, अब क्रिकेट टीम में हाजिर हो गए, तो 2016 रूल 18, उनके पास इतना फंड है, फंड खर्चा नहीं होता है, और प्लांटेशन करने की इतनी जगह है, प्लांटेशन नहीं होता। क्या बात है, कमाल है ना, पैसा भी पड़ा हुआ है, जगह भी खाली है। और एक बात मैडम में है रूल में कि कैंपा की जो ऑर्गेनाइजिंग मीटिंग होगी, इन सब होगा, तो आपको ट्राइबल सेक्रेटरी इनको मीटिंग में तय करना पड़ेगा कि ट्राइबल को क्या क्या जरूरत है। वो कभी होता नहीं है, या वो कभी होता नहीं है। तो जो कन्वर्जेंस की बात होती है, तो कन्वर्जेंस के लिए पैसा पड़ा है, जगह खाली है, टेक्नोलॉजी का अभाव है, लेकिन एक दूसरे से बैठते नहीं है, लेकिन है मीटिंग में है। आप रूल देखेंगे कैंपा तो अप्रूवल है। तो ये ऐड की बात एक साथ करना और उसके साथ में एफआरए के साथ मिलाना, तो इन सब की चीज के लिए वी हैव प्रपोज टू हैव ए प्रोफेशनल, एक न्यू ब्रीड ऑफ प्रोफेशनल, फॉरेस्ट्री का नहीं, ट्राइबल डेवलपमेंट का नहीं, एंथ्रोपोलॉजी नहीं, बॉटनिस्ट नहीं, जियोलॉजिस्ट नहीं, इकोनॉमिस्ट नहीं, इज ए न्यू ब्रीड like your administration. Yeah, it's a new cadre. It's a new cadre of tribal development management. Tribal development management. The my last thing. We are having number of tribal research institutes, TRI, academy, anthropology university. We are teaching tribal studies. Sometimes we also talk of tribal development, but not management. And these are the issue of management. So the new cadre of tribal development management, who will be taught all those things and criteria, indicator for measurement how to go better. So these are some of the things I wanted to share, and I opened my heart and allowed Otaji and his team, my young friend Raju, for being with us and listening to me. Thank you very much.
Thank you, Dr. Rai, and it's all very wonderful and relevant and also very essential and tangible suggestions. So, of course, we know that tribals themselves know that they say, "Amara pani, sorry, Amara Jameen, Amara jungle, Amara pani." This is our own land, our own forest, our own water. So, we others coming and occupying their properties and assets. This always we heard when Bureau Commission has done thorough study of the tribal rights. I have been along with him during Dilip Singh Guria's Scheduled Areas Commission. Whenever we go, this is the word we used to hear from the various associations and civil society organizations. So these are the very relevant suggestions. So thank you. And now I request Shavana Khanna, Advocate Supreme Court, to present a legal and constitutional rights of tribal communities in India. Madam, over to you.
She is connected.
Very good afternoon to everybody. I hope that you can hear me.
Yes, it's loud and clear.
Okay. And the PowerPoint is clear?
Yes, it is. Yes, it's clear.
Wonderful. Thank you so much for having me. I'm so happy to be here with all of you. And at the outset, I must apologize for not being able to be there in person because of certain health issues. But still, it gives me great happiness to see so many familiar faces on the panel and also among the participants here. Thank you so much, and look forward to a really useful and productive discussion. I will take you through some of the key issues that I feel are of importance when we are looking at the Forest Rights Act. And from the perspective of the law and the constitution, right at the outset, just to give you a little bit of a background. This is not moving. Yeah. So I think it's important for us when we are looking at the Forest Rights Act and we're beginning our discussion in a sense on the Forest Rights Act and the problems that we are facing with implementation, to just cast our mind back a little bit on the origins of certain constitutional principles relating to forest rights, Adivasis, to tribal development. So I want to remind you of the Panchi Doctrine, which was adopted at the beginning of our independence. Many of you are familiar with the Panchi Doctrine.
Your slides are not moving. My request to just see if you can move your slides.
I'm sorry?
Slides are not moving ahead. They're stuck. Slides. PPT. PPT is not moving.
The slide is not moving?
No, it is not.
Okay, I will just do the slide share again in case that works.
Yes.
Now is it?
Yeah.
You can see the slide saying Panchi Doctrine?
Yes, sir.
Okay, wonderful. So just to remind us that at that time when we gained our independence, we had developed these ideas relating to how we're going to deal with the tribal regions and the tribal populations. And the idea was very clearly that we should allow the Adivasi populations to develop along their own lines of genius. and not superimpose an external system on them, respect their rights to land and forests, allow them to develop their own people in terms of administration, etc., rather than introducing outsiders into tribal territories, ensure that these areas are not over administered. And these principles, you will realize why I'm reminding you of them. I'm having some difficulty with this slide movement on my computer. Okay. The reason why I feel that it's important for us to look at when we talk about Adivasi rights, it's usually the case that we start with Article 244 and the 5th schedule. My principle has always been that we must begin with the beginning of the Constitution and look at the preamble of the Constitution, which recognizes that all citizens in this country will have access to these basic principles of justice, liberty, equality, and fraternity. The other thing that is very important to remember is the principles relating to fundamental rights and directive principles. Each of the provisions relating to Adivasi rights in the law can be traced back to the fundamental rights chapter of the Constitution, to Article 14 relating to right to equality, Article 15 relating to affirmative action, 21 relating to the right to life and livelihood and dignity, and 25 and 29 relating to the right to freedom of religion and spiritual practice. All these fundamental rights have been recognized as part of the constitutional framework, which recognizes the rights of Adivasis. We also have the directive principles of state policy, which talk about distributive justice, having special protections for scheduled tribes in terms of their resources. The provisions relating to panchayats in particular, I want to remind you about Article 243M, which directly relates to the enactment of PESA. So PESA has a special constitutional status because it has been enacted as part of a constitutional mandate. And then, of course, we come to Part 10 of the Constitution, which is Article 244, read with the 5th schedule, and other special provisions which are relating to the formation of the National Commission for Scheduled Tribes, the classification of scheduled tribes, and then there are what I call the Article 371 series, which are the special status to states from the Northeast. I noticed that today people from the Northeast are not present, but nevertheless, when we look at the Constitution, it's important to recognize that the Northeast is very much part of the constitutional framework. So what does, say, the right to equality, which is a fundamental right, mean for Adivasis and forest dwellers? When you look at it technically, there are 3 ways of understanding the right to equality. One is a very, very rudimentary formal equality approach, where you say all citizens, all people in the country are treated equally. The law will treat them equally. And then after that, what they do with that equality, that is their business, and it's not the business of the state. Now, our approach in our Constitution is not this approach. We have adopted the second approach, which is the substantive equality approach, which recognizes the fact that there are certain communities in our country which have been historically disadvantaged. These are certain minority communities, these are women, these are people with disabilities, and also Adivasis and scheduled tribes and other backward classes. And the Constitution puts a mandate on the state to give special attention to these communities, to bring them on a par with other communities. And that is the approach to equality that our Constitution has adopted across the board. We have rejected the formal equality approach in our Constitution. When it comes to Adivasis, I think it's important to recognize the third approach, which is the right to development approach. And I have often argued that this is the approach that has been adopted by our constitution, which recognizes not only that Adivasis have they have been historically disadvantaged and marginalized, but because they have a different cultural and customary history, there is a need to recognize that how they define development, how they define progress, how they define what governance and justice and management of resources means to them. They have a right to decide what kind of development they want in their areas. So this is a very important connection between the chapters of the Constitution relating to fundamental rights and directive principles and the 5th schedule of the Constitution, which recognizes that we are a constitution within a constitution when we come to 5th schedule areas. And this is not something that I have come up with. I don't have that kind of, genius. This is a definition that has been given by the Supreme Court of India in the Samta judgment, which clearly recognizes that there is a developmental rights of Adivasis in scheduled areas are recognized as part of their constitutional rights. This is something that we must remember whenever we are talking about anything to do with the 5th schedule. So the Samta judgment, of course, was 1997. But we also have the Niyamgiri judgment of 2013, which has recognized that when it comes to any kind of developmental activity which requires forest diversion in forest areas where Adivasis are there, the decision-making process must actively involve Adivasi communities. And this quote from the Niyamgiri judgment is very important. I would, of course, urge all of you who have not already seen this judgment to please read it, because it encapsulates very, very in great detail the things that I have said in just a few minutes. Now, let's also recognize the fact that when it comes to equality, freedom, life, and liberty for Adivasis and forest dwellers, there are also a large number of special laws which are protecting their resources, their lands, and their rights to governance. I'm probably reiterating stuff that you already know, but we need to mention that there is the Panchayats Extension to Scheduled Areas Act and state level Panchayati Raj laws. There are in each state with 10th schedule, with 5th schedule areas, and also in the Northeast and in many states which even don't have scheduled areas, there are laws which prevent the alienation of tribal lands to non-tribals. And this includes even the state in many instances. There is the 2013 Act relating to land acquisition, which gives special rights to scheduled areas and scheduled tribes. The Samta and Niyamgiri judgment I've already mentioned, and the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act. So the reason why I have traced this journey for you is because when we're Rights Act, we must not forget that it is part of an overall structure, a constitutional structure, a statutory structure, which recognizes that there is a special status for Adivasis and for forest dwellers in our constitution. And it has a history to it. It is not just something that has dropped from the sky in 2006. So when we come to the issue of historical injustice, I don't think I need to get into this. Many of you already know about when we say historical injustice in the Forest Rights Act, what does it actually mean? As in the morning session, it has already been mentioned by the keynote speaker that from independence till today, if we look at the number of people who have been displaced due to developmental projects in our country, 40% of those displaced people are Adivasis, whereas the population proportion of Adivasis is 8 to 8.5. So let's be very clear about it, that when it comes to development, Adivasis have faced a disproportionate burden of the price of, whether we say that this is for nation building, whether we say this is because we adopted a certain mode of development, regardless of what that may be, but a disproportionate burden has been borne by Adivasis. Now let's come to the Forest Rights Act. These are figures that you already are aware of. I don't need to go into it. Now, the Forest Rights Act, which was notified in 2006 and came into force in 2007 in December. A very important part of the Forest Rights Act is the preamble. It's one of those rare legislations which has a very detailed preamble. And in my practice in the last 15 years, I have found that the fact that we have this preamble has been a very, very important tool to what we call an internal aid to interpretation. I will be discussing a little bit more about this in the session that we do tomorrow. But just to give you an idea that there are certain key elements in the preamble of the Forest Rights Act, which are important to always remember. One is, of course, the reference to historical injustice, the fact that Parliament has recognized that there is historical injustice which continued after independence. And now the effort is to undo this historical injustice through this statute. The second part is that forests are an important source of livelihood and food security for forest dwelling communities. There's a recognition by Parliament of this. The third thing that is really important is that forest dwellers are part of the forest ecosystem and are important for the preservation and conservation of forests. This particular portion of the Forest Rights Act is extremely important because if you look at conservation legislations, wildlife protection legislations prior to the Forest Rights Act, and even conservation initiatives by the state and also by civil society prior to the Forest Rights Act, there has always been an antagonism with the forest dwellers, that either it is the forest dwellers who should stay or it is the wildlife which will be conserved. It cannot be both things. The Forest Rights Act recognizes that actually they are not just not only are important for coexistence, but they are also important for preservation and conservation. So this is a very important change in the law. The FRA recognizes and vests forest rights and provides a mechanism for that. And the final thing which I always feel is really important, and it really in a sense represents the generosity and humility at some level of Parliament in recognizing that forest dwellers have suffered because of government development policies and projects, and recognizing that fact and acknowledging that mistakes have been made in the past. I think that one of the most important parts of recognizing any kind of social marginalization is to recognize that there is a problem. If you don't recognize the problem, if you don't acknowledge the problem, you're not going to be able to solve it. So this is a very, I'm dwelling a lot on the preamble because I really think of it as key to our work in the future. Now, when we look at the scheme of the Forest Rights Act, there are three very important aspects which I focus on. One is that there is a statement of a substantive right, that there is a vesting of forest rights by Parliament and the non-obstante clause, which we'll come to in a minute. But the fact that the rights have been recognized by Parliament and these rights have been listed in one place. When you read the rights listed in section 3.1, you will recognize the fact that many of them are there in other laws, rules, court orders, circulars, etc. But this is the first time they've all been collected and put in one place. This is really important. The second thing is the mechanism for recognition of rights, which places the Gram Sabha at the center of the decision-making process. Again, this is an important and very, very significant departure from the procedures for rights settlement that were there in earlier legislation, such as the Indian Forest Act and the Wildlife Protection Act. This mechanism is really important. So, and the third thing, of course, is the power to protect, preserve, and conserve and manage community forest resources. Again, we will be talking more about this tomorrow. But this is a very important right which is recognized, and it's not just a right, it's a power and an authority in the Gram Sabha. There is a fourth area which I, as a lawyer, feel it's important to always point out, that the Forest Rights Act makes a very important and significant departure from the traditional rules of evidence, which we have sort of internalized through Indian evidence.
Sorry for interruption. Time is running out. Kindly conclude it because we have a detailed session tomorrow. So we can wind up in another 2 minutes, madam.
Certainly, I will wind up in 2 minutes. I am actually coming to the end of my presentation. So a very important departure has been made from the Indian Evidence Act and the rules, very, very strict rules of evidence that are contained in that statute. And therefore, in Rule 13, allowing the claimants of forest rights to produce not only documentary evidence of various different kinds, but also to present physical evidence, also to present oral evidence. And this is a very important departure. As a lawyer, I have found this to be extremely significant. I will come to Section 4 tomorrow. Finally, I want to just reiterate that the concept of forest rights in Forest Rights Act, there are certain very significant things that bear repetition. One is that the Forest Rights Act is not creating any new rights. It vests and recognizes pre-existing rights in forest dwelling scheduled tribes and OTFDs. So we must always be very clear that this is not a land distribution law. It is not a law which is giving the state some kind of, benevolent powers or authority. It is not a scheme for, helping the poor by giving them free rations. It is not comparable to any of those schemes. It is recognizing pre-existing rights which had not been recognized prior to 2006 because of the colonial legislative landscape. The second thing is that the rights are vested by Parliament, and Forest Rights Act provides the statutory process. So the vesting has taken place on 31st of December 2012. The FRA provides the process by which now this vesting is going to be converted into paper and taken down in records. The third thing which I have already mentioned is that forest rights are very intrinsically linked to the fundamental rights and therefore to the duty of the state to recognize and protect the fundamental rights of Adivasis and forest dwellers under Articles 14 to 25 of the Constitution. And finally, the individual and community rights of forest dwellers, along with that, FRA also vests Gram Sabhas with the responsibility to protect and conserve their forests. I don't think I need to reiterate, Dr. Saxena has already mentioned how poor the implementation of the Forest Rights Act is. And the data is there in the monthly progress reports placed before before all of us, by the Ministry of Tribal Affairs. 50% of the claims actually only have been recognized, the 50% of the claims filed. And in effect, only 3% of the potential CFR rights and only 12% of the individual forest rights have been recognized, even according to the government's own data. Finally, I just want to end with a quote from Dr. B.R. Ambedkar, the architect of our Constitution, where he recognizes, and I'll read it out, rights are protected not by law, but by the social and moral conscience of society. If social conscience is such that it is prepared to recognize the laws, rights will be safe and secure. But if fundamental rights are opposed by the community, no law, no parliament, no judiciary can guarantee them in the real sense of the word, close quotes. So the concluding point that I want to make here is that there is an aspiration of the Adivasi and forest dwelling communities that the Forest Rights Act represents. But it is an agenda that is in our hands as people from the civil society, as people from the administration, as people in decision-making positions, as people from the community. And it is up to us to make the Forest Rights Act work. And if we don't stand up to our responsibility to make it work, then this Forest Rights Act also will become another promise that remained unfulfilled. Thank you for your time and your patience.
Presentation. And of course, as you rightly said, as Ambedkar rightly quoted, ultimately that depends on the people who are there, maybe the bureaucrats or maybe the civil society organization or the community itself. We should be diverse with the law. Unfortunately, what we come across is the dominance of some of the bureaucrats. They are not taking human rights in the true spirit. And if they take this human right as a true spirit, considering the human rights approach, then definitely there won't be any problem. And tribals will not fight for their rights. And that's thank you so much. And we have Dr. Kundan Kumar, of course, he is joining us from Toronto, from University of Toronto, from Canada. Now it's the time, maybe it's around 3 a.m. in the early morning. And really, it's your commitment shows that you are joining from Toronto to that to be one time. So warmly welcome you to speak on reconciling the ecological security and tribal livelihoods through FRA, global perspective.
Thank you, Dr. Raju. Can you hear me clearly?
Yes, it's clear. Please,
thank you so much. Well, it's 3:30 in the morning in Toronto, and I've been listening since the beginning. Thank you so much for inviting me to this meeting. I think the reason I've been found useful or my presence has been sought is because I'm familiar with both the Forest Rights Act. I've been kind of involved with it since it was being drafted and have been accompanying the journey throughout, as well as what is happening at the global level. I think the topic that I've been asked to look at is looking at how do you combine global tribal livelihoods through Forest Rights Act with ecological security, and what do we learn from the global kind of experience. So bear with me, and I'll share some slides and some ideas, and let's hope that this helps all of us to kind of clarify the stakes that we are facing, the stakes that are at hand. So looking at, starting from kind of global perspective, that we know that from livelihood perspective, we know that indigenous people, local communities, that is Adivasis and forest dwellers in Forest Right Act parlance, are the most marginalized and vulnerable people in the world. So the major part of the bottom 1 billion forest, more or less. And largely, this is because of the relationship and the tenurial relationship with the land and resources that they depend on. And many of them have inhabited, or they inhabit high biodiversity and fragile landscapes. And many of them have practiced systems of customary governance and stewardship, including in India. And if you look at the data and figures, so studies show that indigenous people and local communities, Adivasis and other traditional communities across the world, they claim, mostly through collective land territories, through ancestral rights, nearly half the world's terrestrial area. So that's like a very big number. And we also find that very clearly that 80% of the remaining biodiversity pointed out by others earlier is found in the territories of indigenous people and local communities across the world. So these are I'm not pulling this out of hat. There's like a ton of literature on this. in peer-reviewed literature, in top journals such as Science and Nature, etc. One of the things that we kind of some of us have calculated is that indigenous people, local communities actually manage at least 24%, that is 54 billion gigatons of the global carbon stored above ground, the world's tropical forests. So what we're looking at is that this means the implications of this is that indigenous people, local communities are really important for not only for terms of their own livelihoods but they're also important for humanity as a whole. Before going to the next part when I talk about the livelihood and ecological security nexus, I just wanted to share with you some of the numbers across the world on what are the kind of recognition of customary lands of indigenous people and local communities in selected countries. Some of these are developed countries, some of them are developing countries or medium developed countries. And you can see that there are countries where up till 44% of the total land area has actually been recognized as the customary or ancestral land or territories of indigenous people, local communities. For example, Canada, the First Nations have the government recognizes 44% actually, and the First Nations actually claim up to almost 80% of the land mass of Canada. Similar situation in places like Australia, and I think all of you must be familiar with that. What this also tells us that when we talk about 46 million hectares, which is around 12% or 13% that Dr. N.C. Saxena talked about CFRs and habitat rights and other rights under Forest Right Act. So it's a pretty small number. It's not something which is really big. We think about 6 million hectares if you compare what has been done in other countries. Looking at the numbers and why is collective rights and commons of indigenous people, local communities a core solution to climate biodiversity ecological crisis? I think we all know that we are facing this huge crisis of climate change, conservation, ecological degradation across the world. And without going into the details of this, I would just say that the most authoritative sources, which are kind of the scientific consensus and policy level consensus at global level on the critical role of indigenous people and local communities in biodiversity conservation. If you want, you can look at the IPBES report 2019, climate mitigation and adaptation, IPCC, this was mentioned earlier, the global land restoration. This is just now the report came out from UNCCD, the Convention on Desertification. They kind of really center the role of indigenous people, local communities in preventing desertification and in ecological restoration. And multiple peer-reviewed publications. These are kind of analysis of data, numbers, etc., everything to kind of really show how important the role of indigenous people, local communities, and their collective rights and their governance is for climate change and conservation. And this was also recognized by the global community and in the COP26, the governments of various countries and donors agreed to put $1.7 billion commitment for supporting indigenous people and local communities. And if you look at, again, without going into the details of the data, but I can kind of provide you the information if anybody is interested, is that the evidence at this point of time tells us that supporting indigenous people and local communities in their role as stewards, as governors, as leaders of conservation, climate mitigation, ecological restoration is a just, sustainable, and effective nature-based solution, if you want to say. They are the real nature-based solution. And the second thing which has not been really talked about at international level, but which is very important for us in India, is that when you're transferring to meet this role, the humanity as the society or the countries need to transfer resources to indigenous people, local communities, or the tribals and forest dwellers to play their role in ecological security and climate security that can also act as a strategy for improving their livelihoods and rural economy. So this is happening at the global level. This is as applicable to in India. It's a win-win situation. So some of the ideas that we have, or some of the experiences that we are having at the international level on the win-win situation of ecological restoration and climate change, climate mitigation led by indigenous people, local communities. In cases where rights are recognized, they have clear governance powers. That is much more effective for ecological and climate security, as shown by global and Indian evidence. Again, there are tons of peer-reviewed evidence which show this clearly. And it's every day this is being, and this is acknowledged by the key global processes. Transfer of large amount of resources to communities will generate employment, livelihoods, and local development. So if you, because this is an imperative for humanity, not just for tribal people, that if you transfer that this, we have to mitigate the climate, we have to conserve, and if you do that through indigenous people, through local communities, that will create employment, livelihoods, and local development. That's the ecological security, livelihoods nexus that we are talking about in context of India. And another problem that we are facing is the large-scale unemployment across the world amongst the youth, especially in the rural areas, in the forested areas. And this can also create productive and gainful employment to local youth and women in rural areas. And most important, I think, and Dr. S.B. Roy pointed out about and also Dr. Panchi Doctrine pointed out that, when you're doing top-down climate mitigation and conservation projects, there are a lot of conflicts, and we are familiar with them, including in India. And this can also address those conflicts. Now, FRA's importance for this approach, which is basically a participatory, empowering approach, which basically looks at the agency of indigenous people, local communities, tribals, and forest dwellers in India as their agency as leaders in conservation and climate change mitigation and ecological restoration. For that, FRA is extremely important. And that's where we look at ecological security and livelihood, kind of the relationship between the two. And I would like to point out, and I think Shomona captured that earlier, as well as Dr. Roy and Dr. Saxena talked about it, that Forest Right Act, when I go on the global the global milieus, Forest Right Act is accepted as a model, as an example to the world, as a progressive legislation, which kind of covers all the bases and provides collective forest rights to indigenous people and local communities. So this is kind of really, everybody basically talks that, okay, look, how can we have Forest Right Act like law in, say, for example, Myanmar, or for example, in Thailand, or in other countries. So there's a reputation that Indian is really congratulate the Indian Parliament to have done this, passed this law. And looking at 40 million hectares of degraded forest land, which is potentially CFR land and other kind of categories of land that can come under tribals and forest dwellers, community governance. These are lands which are prime target for climate mitigation and conservation. And that investing in those lands through Gram Sabha, further restoration for climate mitigation, can not only improve the ecological security, but also lead to livelihood security for tribal and forest dweller communities. And we have so many examples of this. Means all of you are familiar and all of you have worked on it, that there are examples across India, in Maharashtra, in other places, where both livelihood security and ecological security has been achieved through Gram Sabhas, through the implementation of Forest Right Act, and by empowering the Gram Sabhas and supporting them in restoration, climate mitigation. So I think scaling up of supporting CFR governance and linked to ecological restoration by Gram Sabhas is really important, and basically should be an important strategy, core strategy for climate mitigation strategy or conservation strategy in India, and as well as afforestation, ecological restoration strategy in India. And this can lead to better outcomes. We have seen that on the ground. This can lead to improved resources for tribals and forest dweller livelihoods, because the money that is flowing there, it can improve the livelihood outcomes in terms of improved forest condition, improved MFP production. It can link up to the whole processing, market chain, market economy, market chain linkages. It can create employment for tribal and forest dweller youth and improve local economies. It can reduce conflict, which are occurring because of climate mitigation, existing climate mitigation, conservation, and forestation programs. And that's a big problem for people who have been following this. If you look at the land conflict database that talks about conflicts on plantations. There are quite a large number of conflicts that have been documented because Forest Department is trying to use camper funds or other funds to plant on lands which Adivasis are claiming as their lands. So this is something which I would say that climate mitigation, conservation, nature-based solutions has to be linked with Forest Right Act and the rights of tribals and forest dwellers. They're building their capacities and really work on this. And what are the way forward is you have to urgently scale up CFR rights recognition across the country. It's not happening. As pointed out by Dr. Saxena, as pointed out by others, we are not really investing in it. Where is the mission mode? And thankfully that, Orissa government is now talking about a FRA mission. But do we have the capacity? Who is investing in capacity building at the national level, at the state level of the civil society? There's not enough support. And I think really my request to Niti Aayog is to really look at how do we kind of move forward in building the capacity or implement recognition of forest rights on a mission mode at a national level. And this includes building capacity of the Gram Sabhas for post-recognition governance of forests. It includes livelihood activities linked to forest and forest governance. Another thing which is very important is that all the afforestation, forest restoration, forest-based climate mitigation funds, which literally is now in almost 100,000 crores, camper monies there, other sources there, that should be channelized, at least major part of it, through Gram Sabhas for CFR's restoration. We have wonderful examples of Gram Sabha restoration by communities of forests, done at low cost, efficiently. We don't even have a proper study by the government to see, whether what has really happened in terms of, how well have Gram Sabhas performed. It's not part of the narrative, but there is enough evidence in India and from global sources that they're much more better. They're much better than, government in protecting forest, in managing forest, in restoring forest. And one of the suggestions that I have is that, incentive scheme for Gram Sabha based on broad indicators, the ones like Dr. S.B. Roy talked about, and simple broad indicators like forest cover increase, forest cover and biodiversity indicators. That if the Gram Sabha is protecting a forest well, if it is improving the forest, then you provide a lump sum payment to them per hectare on their CFRs. And of course, supporting forest-based livelihood in CFRs. So these are some of the pathways. Couple of suggestions, incentives. I was thinking that if you just put in an incentive of 2,500 rupees, 2,500 per hectare per year, it will cost you, if you recognize all the potential CFRs, and it will cost you only 10,000 rupees annum, which is actually less than what we are spending on afforestation. You basically have protection of 40 million hectares. You can provide support. And similar things have been done in other countries. China has transferred almost $50 billion for payment for ecosystem services to farmers and farmers collectives. And this can also lead to, if you channelize money to Gram Sabhas, you would have generate millions of person days in employment. You can create tribal youth volunteers as provide employment to them in Gram Sabha-led forest management. And the funding already exists. It's just not being channelized in the. And as we know that actually the current use of the funding that goes for ecological restoration, climate mitigation is actually not being effectively utilized, especially for forestry. And it's a problem for all of us. So these are some of the suggestions. And anybody who wants to reach out to me for literature or that I've talked about, please, you're free to do that. And I'm really thankful to everybody. Any questions you can share with me. Thank you so much.
Thank you so much, Dr. Mandal. In fact, it's a wonderful opportunity to all of us to learn the global best practices and what the global level initiatives are happening towards conserving the diversity as well as the rights of tribal communities and the indigenous groups. I was into University of Toronto last 3 years back. In fact, I had interacted with Dr. Yadav, who is the registrar of Toronto University. And we learned a lot of things from there, also from Canada. Canada's initiatives for the indigenous communities and of course Canada, though it is a developed country, it's doing a lot of initiatives for the indigenous groups, including protecting their land, territories, and also providing all other economic assistance, social security, and wonderful opportunity. Thank you so much. Of course, we learned a lot and we have many things to carry forward. And maybe during the last session, the end of the session, there may be some questions from the participants. Now I request Madam Panchi to present on the intersectionality of laws, the Forest Rights Act, and FCA and CA perspective building. So another request is it's almost like we are reaching the concluding at lunch. So, yeah. So
amplify the voice. I was actually keeping my dialogues ready when I was asked to quickly sum up in the last, being the last panelist, obviously in on a panel means like it's like a relay race. जो backlog होता है, you have to cover it up. So I'm going to try, and I'll definitely try. And I think it is also important because a lot of the points from the morning onwards have been really laid out in front of us. And in fact, I will start with referring to 3 or 4 very important. So this session is about context setting. And since the morning, actually, we've been setting the context. And I think people in this room already know the context. So, our job is actually here to just synthesize what all of us really know in the room. And that's our challenge. And that is also our, our privilege to be able to do that. So thank you for this opportunity. So this morning onwards, I think 3 or 4 things really came up. Point number 1 was about access and entitlement to land and forest is paramount. This was one important statement that came up. Second point that came up was interdepartmental coordination is a challenge. Commensurability of legal procedures, forest diversions, forest rights, all of this is a question for government to address. Of course, many presentations have said progress on FRA is dismal. It's problematic for a whole variety of reasons. It is, and the question is, and the question you raised about displacement to development projects. So when we are embedding context of and discussion on FRA in the context of development, we have to also bring in the lens of the development projects. And before I go further, I just wanted to say that both the challenges as well as the opportunities of FRA actually lie in also how we approach FRA. So is FRA a settlement process, settlement of claims process, or is FRA a recognition of rights process? So is the manner in which we approach FRA will actually determine how we take the process forward. And we, since morning, we've been hearing both these aspects. There's a process, there's a bureaucratic process that we need to undertake to settle claims because the law needs to be implemented. But there is also an expectation of the law. There's an expectation of the recipients of the law and everybody else that this is not just a matter of settlement of claims. This is a matter of recognition. It's a political recognition of rights. So I think it's how we take this process forward has both challenges as well as opportunities in these approaches itself. So, and I think this has been said a few times since morning and several times before as well, that tribal areas and geographies that we are talking about both contribute to India's development and economic growth and are impacted by it. So there's a twin thing that is happening. These areas actually, at least partly, some aspects of tribal economies feed into the larger economic growth conversation, not adequately, definitely. In fact, there's been a push that we need to recognize it much more. But there is you actually are part of the whole economic growth. These areas are part of it, as well as are impacted by it. And in this context, I think I think the statement did come up that there are several government schemes and projects that itself are impacting tribal areas. So what are these projects? What are these projects, schemes, programs that are critical for government to operationalize various laws in the country, various schemes in the country? These projects and programs are designed as part of economic policies. So whether it is construction of roads, extractive industries, commercial plantations, agroforestry, all of these are actually operationalized through schemes, and projects and programs. So there is a contribution and there is an impact that is taking place. The second kind of projects and schemes that we are looking at in tribal areas, and of course in different parts of the country as well, is those projects that are designed to accommodate the impacts of the previous schemes and projects. So when you actually have a road or a mine, there is an impact. In order to compensate that impact, there are newer projects, which is what has been brought up in terms of compensatory afforestation or land for land, or what do you do with common lands, all of those kinds of things. So these are designed to accommodate the impacts of projects. So in fact, what is happening increasingly with compensatory afforestation processes is not just the issue of forest areas, it's also about revenue lands being converted into forest lands. So there is the spread of these impacts is actually growing. And of course, there are larger questions of water, biodiversity, culture. I'm not getting into it, but even if you ever have to elaborate on it, there's a lot of knowledge in the room that we can talk about. The third kind of projects are basically are also designed for protecting certain non-human entities. So wildlife, biodiversity, there are protected areas that are being pushed for. Now that when the space is already shrinking, they create new kinds of impacts. So we are in a cycle of these projects that are being introduced in the same geographies or complementary areas, and all have their own set of impacts. Now, each of these are instances that there is necessarily an interaction with prevailing rights, habitats, uses of Adivasi and other traditional forest dwelling communities. Now, why I'm saying this is that when these projects are introduced, and all of us know this, the ability of the community to depends on their extent of marginalization or political power. So, and this is not, sometimes this is, we will talk about forest dependent landless Dalit communities versus Adivasi communities. Adivasi communities versus Adivasi communities. So there are these conflicts taking place in the same, and the abilities of different communities to be able to negotiate and losses of each of these projects and schemes very differentially. So, and these become challenges both for government and non-governmental actors. Now, obviously, there are laws, policies, regulations, the constitution which Mona spoke about, through which these processes need to be governed, through which actions are controlled, which can also become tools to prioritize. Now, the thing is that we've been speaking about laws. The thing is, even within laws, and if that is considered to be a tool to operationalize, to govern, to control, all of that, even within that, there is a hierarchy. So, there are legal procedures with contradictory priorities, not just wildlife and Adivasi rights, but what should be done to that place? Should we actually construct a road, or should we let that area be? In situations like that, what kinds of programs, processes, policies take prevalence or are higher on priority, and what is lower on priority? This becomes a big issue. And here, in this, I'll bring back the question of settlement of claims versus recognition of rights. Now, if a certain project, a certain development project is of primary importance, settlement of claims might help move further. But if it is a recognition of rights process, much more emphasis has to be given to inclusiveness, consent procedures, deliberation, democracy, those kinds of things. So the approach of how you're dealing with the same question will depend on how we are approaching the Forest Rights Act itself. So the reason I'm saying all this is that we need to locate the Forest Rights Act and its implementation challenges and opportunities within this context. And I think unless and until we are able to very specifically talk about this context, we may say that, okay, it's not working, it is working, figures are correct, figures are not correct, which is all fine. But the thing is, understanding the intersectionality of laws and maybe some legal corrections are possible. You can make laws commensurate with each other, you can get departments together. But actually, how do we actually recognize the hierarchy of laws and laws and planning procedures, and how do you prioritize? So I think prioritization actually is a very important aspect that we need to talk about, and I'm glad Niti Aayog is here, because this prioritization exercise is exactly what we are, institutions like Niti Aayog can get into. So in some ways, we need to talk about how do you actually embed recognition of rights in how planning takes place. How do you embed these processes to that? For instance, in the morning, the question came up about, just granting pattas is not enough. Possession and other processes are important to close the loop. Now, that is one, that is the maybe how we actually would look at FRA. But also, along with that is also an education to know that you may close the loop of settlement of rights or recognition of rights, but is that land actually demarcated for something else? What are the other local, national, international contexts that may hinder the operationalization of your rights itself? So I think that kind of those kinds of processes actually through policy making will become very important to. I think they'll make FRA a far more effective process and not just an end goal of settlement of claims. And there are several opportunities. Actually, there have been lots of people who, and I'll just end with 3 or 4 points, that there've been, there's always been a talk about upstreaming consent procedures. Let's not do it at the level of certain developmental projects. You upstream it in planning, and laws such as PESA actually give you space for that. Why don't we plan for these processes through much more elaborate processes, consent being very much part of what should or should not come up in that, in a particular area. And I think, yeah, I mean, there are little things about, about really, understanding that processes such as FRA are about, and as Shramona pointed out, the preamble talks about recognition of rights. Where does this idea of cancellation of rights come in? In some instances, we've been seeing that rights once recognized are being cancelled. Whether the Forest Rights Act actually doesn't really talk about a cancellation of rights. So, I think some of these hindrances also need to be brought in place, because then there'll be a much more popular, acceptance, understanding, and commitment towards Forest Rights Act. And I think the point that really came up even in your presentation about, I think this whole issue of R&R, rehabilitation, process of even talking about development, one of the main things that constantly comes up is there is a complete trust breakdown when it comes to R&R. Because there are very few good examples to show that there have been good R&R that has taken place. Now, if you're able to demonstrate things like that, for instance, actually to start with, do we even have figures to know what is the level of R&R? The figures that you spoke about, even about displacement, do we have the figures? Can there be a systematic process of even trying to do this at state levels, at district levels, and bringing it together this data? That might give us the understanding of what the what the scope of this, how deep the problem is, so that we can start even beginning to tinker with it and then recommend. And of course, I'm sure there's going to be much coming up in the next few days. I have not even got into issues of climatization, etc. There are multiple challenges at multiple levels that we are talking about. But I think it's important for us to even recognize how we can even look at opportunities within those challenges and address. Thank you. 10 minutes? More than 10 minutes?
Thank you so much, Madam Panchi. And of course, you talked to the relevant and important and valuable points. So I request the participants 2 questions from the audience and 1 question from the virtual participants. So those who want to put some more questions, you can put it in the boxes so that we definitely see that how the so whenever we put out a roadmap, we will take into consideration those suggestions of the valuable points. So myself, Enchitas, an old student of anthropology. I've been listening from the beginning, from the madam regarding the implementation of the FRA, they are doing it straight. The taking up so nicely. And Shobha Madam had told regarding the constitutional availability for the tribal labor. See, since last 70 years, FRA is 2000. 70 years, we are doing some development, forest development, tribal development, all that. But how come the SDI, the Human Labour Index, rightly Bhagavan told, it is lowest in tribals. Then, very interestingly, in Saxena, he told that the FRA is not that effective or not doing that good. But FRA is, I think, 2006. We have been doing 70 years of tribal development. 70 years of development. Lots of money is flowing to the development. Still, we are discussing development, tribal development. And my actual question, maybe the part of the question, rightly solved by Bhavan Babu, that the footballers playing cricket. Footballers playing cricket, because you don't in anthropology, those are related to forest and tribals, they should come to the picture, not the other. It's the right question. But my main question, particular question, is open for what is the role of the forest department in this forest act and the tribal, because mostly tribals, rightly tribals, almost 9% of the country. Almost the 50 states gathered here to discuss and answer the questions. So what is the role of the forest department for the tribal development and for executing the tribal plans, or the, what is in our constitution for the development of the tribes or for the protection of tribes? Because they are protecting the tribes. I feel as since last 6 years I've been working in this field. I think they have. I don't know what to do. So my only question is, may I know what are the specialties of the forest people, forest department people, how they harass that the other administrators, the planners, they fail to understand, and still the tribals are very comfortable. Thank you. It's open.
By default, I'm in the position that I'm Amita from IFM. Yeah, you go by the forest policy, forest laws. There is no responsibility bestowed on forest officer. What I would say. It's only bestowed with the conservation of the forest. He did that. Why do you blame him? Act says you conserve it, and if C says don't give it. Conflict is very clear. You have given him a role. Do this. He is doing it. Whereas the tribal development department, I can show you the genogram. If you see your genogram at the down the level, a forest department has a forest guard working at the field level. Your tribal department is not below the program. Who is to deliver the services? If you are working at tribal village, a representative of tribal department has to be at the village. It's not the patrol. So forest department has a representative, tribal department doesn't have a representative. If you come to FRA, who is the member secretary of the committee? Yeah. And you understand the word member secretary? I'll be drafting it. My words will be the final part. Member secretary should have been a tribal officer. Yes, sir. So when you are making a policy, it should be very careful when you are executing the policy. How it will be executed, how will it go down? What will be the impacts of the processes? Quite rightly said it. Like Professor Gopal, who will be the wicket keeper in the football team? Goalkeeper. On the ball sides, which he has to carry on the goal side. All changes and I see, don't say, in FRA I have a few comments, sorry, time is taking away, writing it not up. Where is the institution? It is the individuality playing the role. It is the individuality playing the role, not the institution which should have done it. If it is a right, let the panchayat of that has the full right over. There is a panchayat different and right has to be given by somebody else. In scheduled area, the panchayat should also be the tribal panchayat. They should have been given the full right. They decided. And complemented the role of the forest department should have. There was a policy move in the ministry to integrate both the departments. But it was cut because forest department, MOEF and MODA was to be merged. But somehow again, politics is very different. Thank you.
To relate to that, what you said, I mean, when the drafting was on, I was part of it.
Yeah.
I must mention that with the forest department, at the beginning, I never wanted to part with the act. Originally, they are the one who moved a cab note, forest department. And I was wondering how could they use the word historical injustice. But when it comes to the committee, they hold dear to the heart the post of member secretary because essentially they want to retain their powers. And they so did they are successful. Now it's filthy.
For the politics of policy.
No, it's a kind of psychological. We have to now discuss it or in the end. My name is Ajay Muzaffar. I'm from Srinagar, Kashmir. Actually, I have been writing on this Forest Rights Act for the last 3 years now, because this law was not applicable to Jammu and Kashmir because of Article 370. But in fact, Article 370 was there an impediment to have this kind of legislation in Jammu and Kashmir. Our state could have enacted a similar kind of legislation, or the central law could have been extended to Jammu and Kashmir even before the abrogation of Article 370. Fine. This law got enacted there. It got extended to Jammu and Kashmir when this JNK was. But unfortunately, this law was not implemented on the ground, and in fact, government started milking the forest developers there, and then we raised a voice, and finally, the law was rolled out. But unfortunately, again, the forest department has been made the nodal agency to implement this law. The forest department has been made a nodal agency to implement this law in Jammu and Kashmir, which is totally in conflict with this law. Yes. It's totally in conflict with this law. तो एक ये बात है। दूसरी बात ये इम्पोर्टेंट बात है कि this law has been in operation in across country for the last 16 years, and only 4% of people got the rights under this law. In Jammu and Kashmir, we got the law at the right time, I think, because जितनी भी गलतियां बाकी स्टेट्स में हुई हम उसको ठीक रेक्टिफाई कर सकते थे, but in spite of जितनी भी गलतियां हुई उसके बाद वो बाद में रिपीट करना, तो क्योंकि यहाँ पे बहुत सारे लोग हैं, सिविल सोसाइटी लोग हैं, and we have people from government, so I will request them, because Jammu and Kashmir has 40% forest area and we need this kind of legislation and we need a lot of awareness there. Or people are not getting the rights from last 4 years. So, in spite of the fact that LG Manoj Sinha had put some steps, but still we need a lot of awareness. I would request you to kindly help us in that. Thank you so much.
Document Kashmir, I must say that since the voters of Article 370, there is no hunting, applying this act. So, I mean, other acts for the Juvenile Justice Act also was not applicable to them. See, the idea is to see that especially what you have in Jammu and Kashmir, those are swimming number. If you can locate, I mean, it was the ideal suggestion in 9th plan, 10th plan onwards that you make them settle, give them peace abroad, not wishing there is a act or not, but the state government would have acted upon that.
Regarding to Jammu and Kashmir is concerned, Shahid is recently appointed as a secretary, and he is a very dynamic officer. He is always trying to do something for the tribal welfare. And then recently we were there and we had a review meeting with the BTI, we had a review meeting with the Honorable LG, Lieutenant Governor, and also the Chief Secretaries. We are trying to implement all the laws of Government of India and BTI. Just hopefully we'll find some good results.
They need to involve the local civil society organization. They are not doing that in
Since it is under the Forest Department, they have their own reservations. Because we all know that Forest Conservation Act came in 1980. And when it comes to the Forest Rights Act, it came in 2006. So they have the open hand in the implementation and well organizing system. The Treasury Department is not organized. It is still in the organized stage. We definitely by this conclusion of this session.
I can only tell you what gentleman from JNK has said is very correct. It's a central act and it has been circumvented. I think circumvented in the sense, whereas tribal department all over the country are the nodal department for implementation of FRA. There is a case with a difference where the forest department has been taken. So the central act, the very spirit of the central act, I think I can at least assure you in our recommendation that we can put that.
Dr. Raju, can I ask a counter question? Is it okay? Can I ask a question? And especially this is addressed both to the ministry as well as the state governments and Niti Aayog. If Forest Right Act is implemented in full, as Dr. N.C. Saxena was saying, that we're looking at 40 million hectares of forest going under the control of Gram Sabhas of Adivasis and forest dwellers. It's a massive transformation. It's a massive transformation. It's like unprecedented transformation. If we look at global examples of how these things have been done, there have been huge investments by the governments concerned. And that's why, if you look at 46 million hectares and the transformation that is required to do this, what is the budgetary provision that is being provided for this purpose by the government of India and the state governments? I think that